Our next case is then Mollagee versus Mullaji. Each part have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. How long would you like to reserve for rebuttal?
Yes, 3 minutes.
3 minutes, okay. I will be keeping track of time up here. So I will let you know when there's about a minute left in your time. I'll let you know when your rebuttal time is up. If you want to keep talking, that's fine. Just come off your rebuttal time. And I'll try to let you know when you're about a minute into your time as well. Thank you. If you're being recorded, so when you come up, please first introduce yourself for the record. It's being visually and audibly recorded, so please stay behind the podium if you're able to, and please speak up so we can hear you on the recording. Should not give the name of any child, minors, or victims. Don't know that we really have that to be concerned about in this case, but if you were, if you'd use initials, we would appreciate that rather than the actual name of the child. Beyond that, we've read your briefs and are ready to proceed whenever you are.
Thank you. Good morning. I had to look at my watch to figure out what time it was. Good morning. My name is Gary Godfrey. I represent the appellant, Waheeda, Mullaji. As the court probably knows, because you've indicated you've read the briefs, this is our third appearance before the court. This particular appeal involves the remand by this court in, I think it was September of 2020, where this court found that the trial court had committed an error in modifying the shared parenting plan, basically sui sponte, as the court indicated. In order to understand, if the court will allow me this opportunity, a little bit of history to explain the argument would be appreciated. What's significant about this case is that the last time that any evidence was taken of any nature was at trial, and I think the trial concluded in April of 2019. The significance of that is the child, and I'm not going to use the child's name, there's only one, but we all know who the child is. She was 5 years old. There's no dispute that at the time of the trial in 19, she had been with mother in South Africa from somewhere around the latter part of 2015. Now, I understand, and I've read all of the briefs, I've been involved in this case, Chris and I have been on this case for a number of years, and I understand that there's some concern by the court as to mother's actions, and I appreciate that, and I certainly am not trying to minimize it. But what is significant about this case is that after 2019, there was no evidence taken with regards to the child and best interest. As the court knows, the trial court created its own, in essence, shared parenting plan. This court reversed on that issue, sent it back to the trial court. Trial court then asked each side to submit a shared parenting plan. Thereafter, in I think it was August of 2023, trial court issues a decision, in essence, approving the appellee's shared parenting plan. What is significant, once again, is no additional evidence was ever taken. So the only evidence that the court had before it when it approved father appellee's shared parenting plan was evidence that was at that point in time at least 4 years old. The plan that father appellee submitted was basically the same plan that he had submitted in 2019 with one exception, and that was father took the schedule that the court had suggested in its plan and inserted it into this new plan. The trial court issued a decision on remand, and in that decision, the trial court, went through the 310904 F1 and 2 factors. I'm not going to dispute that. I think that both of us would agree that that is the appropriate standard. I think both of us would agree that the standard that this court's going to look at is, did the trial court abuse its discretion? So I don't think we're going to have a situation where we're going to be saying, I think, different statutes. The problem that I have with this is that when the court applied the best interest standards, when you read its decision, it's the same word for word decision of findings on best interest that the trial court used in 2019. And the question then becomes, how can the court find that in 2023, when the court issued its decision, that those factors are in the child's best interest? how does a trial court use what we call stale or outdated evidence to determine best interest?
Counsel, I'm sorry. Counsel, when we sent this back and remanded it to the trial court, there's a rule of appellate law that says that when you remand something back, it is remanded back to when the error occurred. And the error occurred when the trial court didn't put the best interest in, to go to factors. We remanded it for the trial court to look at it again in regards to that, right?
Well, I actually went and got your decision and read it. You just simply said, this is my version. The trial court simply, the trial court substituted it or included its own terms for shared parenting, which the court cannot
Didn't
do.
follow the factors.
Excuse me?
Didn't follow the statutory factors or something.
No, actually, the court in its decision followed, listened to factors. When you read the first decision, and that's part of the significance of why we're here today. So when the trial court issued its decision granting shared parenting, separate apart from the fact that the trial court committed error because it in essence created its own shared parenting plan by inserting facts, it really did go through the 310904 F1 and F2 factors. I'm not disputing that. My argument today is when you read the trial court's decision in 2023 approving what I'm going to call Father or Appleby's amended plan, word for word, she uses the same, when she goes to the factors. I hate to use this phrase, but I will. I hope everybody appreciates it. It's like a cut and a paste. She took her old decision and just stuck it in a new decision.
But counsel, I guess my question is, we still remanded it to the trial court.
You did.
Okay. And we remand under the appellate case law to the point where the error occurred. So why would the trial judge be able to look at things that have happened subsequent to where the error occurred, which was in 2019?
I guess the answer that I have to the court is when you read this record, after you remanded it, the trial court directed the parties to submit shared parenting plans. So although you may be saying, well, gee, we go back to the error, the trial court directed each party to submit a shared parenting plan. And so on the remand that the court followed, we were instructed, both of us, to submit shared parenting plans. And then what happened next is that the trial court adopted Father Appleby's plan, but used the same facts in approving a plan that is now somewhere around 4 or 5 years old. And that just creates problems because I think we all agree that a trial court is required to find the best and act in the child's best interest. And how do you do that when you don't take any evidence, yet you ask the parties to submit a shared parenting plan?
Did at any point either party request the court to have a hearing to have new evidence submitted to the court regarding that?
No, the court just simply said submit your plans.
And no one objected to that procedure when it was set up and said, look, this is what you're supposed to do. Best interest of the child says you need to take new evidence. It's now 3 or 4 years old and you're relying on stuff from 19 and things have changed.
Well, actually, I would say to you in response that that opportunity was never offered. The court just simply said submit a plan, and we just waited and waited and waited. So I'm not sure that it fits into the category of should we have done something. The court said submit a plan. My practice has always been that when you have a shared parenting plan, you have to have evidence to support it. And I'm not trying to be critical here. But if, to follow on your argument, your question, if the trial court said submit plans, which they did, how do you find either plan is in the child's best interest if there is no evidence?
Well, there is evidence. Your argument is stale. It's not a case where there was no evidence was ever held and the court had nothing in front of it at all. They had evidence from 2019. They could look at that. The argument would be, well, that's stale, and that's not in the best interest of the child because you should find out what's going on in the child's life now rather than 2019.
And when you, if I may, when you read 310904, I would concede that there's nothing that says that the court has to take current evidence. I mean, whether the legislature should have added that or not, but when you read 310904B1, it says that the court shall take into account that which would be in the child's best interest. So by implication, that language, at least to me, implies that the court's supposed to take current evidence, not evidence that is 5 years old or 4 years old, depending on how you measure it. The significance is, how does a trial court fulfill its obligation of best interest when it has no relevant information? For example, the trial court said in its decision, page 19 of its remand, it addressed, for example, the child's interaction, interrelationship. One of the factors, no argument. But what the trial court wrote was about what she heard in 2019. Well, in 2023, the child had been in South Africa now from 2015, whether you measure it from 2015 to 2023 or 2019 from the remand forward. That's a significant period of time. How does the court address that factor?
But the other thing with that argument is what the appellee is saying. Then you could possibly, I'm not saying this was, that the appellant was a wrongdoer, but if you have a wrongdoer that does something like takes the child out of the country or whatever, and then says, well, now I've had the child and they're acclimated to my environment, they've been set up and so forth, then there's never going to be a time whether that may be in the best interest to return that child to the United States. So in other words, they're being penalized by it.
And about a minute left of time, counsel.
I'm sorry?
About a minute left of time, counsel.
Well, I want to answer that. And I understand your argument. I've seen it. I've had it in my own cases. And if the court wanted to say that, the court could have said that. But it didn't. It relied on information that was 4 to 5 years old. So I don't disagree with what you're saying about the penalization argument, but you can't penalize using old evidence.
Okay, so what if the trial court relied on 2019 information, evidence, because that was where the error occurred, okay? And then makes a determination, as it did here, and then wouldn't that be subject to a change in the shared parenting based on change of circumstances in the future?
I'm not sure, with all respect to the court, and I'm a new person to this court, so I always feel a little uncomfortable.
That's all right.
And I'll note you're in your rebuttal time, you may answer the question.
Thank you. I don't think that the court's error was in the application of 310904 factors. I think that's where you and I may have a disagreement.
Okay, that's fine. Thank you.
Thank you very much.
Christopher Reynolds for the appellee, Sajid Mullaji. Judge Carr and Judge Stevenson, I think he largely took what I was going to say out of my mouth in some of your questions. The appellant's appeal here really just raises two interrelated issues, and they're both directed at an accusation that the trial court made a mistake, either by not holding a hearing to take additional evidence or relying on stale evidence, and they're kind of interrelated. The problem, I think, for the appellant here is that this is a reiteration of a problem that she had in this court's decision in 2020. And this court actually laid out a roadmap for her as it relates to what you want to do if you don't think the court has the right evidence in front of it. In its decision from 2020, at the end of paragraph 16, this court said that if a court is, the appellant at the time had argued that the trial court was required to take additional testimony to make a determination on under the best interest factors. And this court said, the responsibility for presentation of evidence, however, falls not to the trial court, but to the parties. Meaning, Judge Carr, to your point, or Judge Stevenson, to your point, had the appellant believed when Judge Glass had issued her order in 2021 to submit amended shared parenting plans, if they thought that the evidence was stale at that point, they could have filed a motion. They could have asked for a hearing. They did nothing. They just did what we did, which was comply with the order.
Well, I think what they're saying is they really didn't have a duty to request it, because the point is, when you file for shared parenting, it's a requirement you have a hearing. You can't make a determination what's in the best interest of the child without having a hearing, an evidentiary hearing.
No, I heard Mr. Gottfried argue and essentially concede that the court based all of its decisions in 2019 on best interest factors that were taken. The complaint is that those factors needed to be updated, or the evidence supporting those factors needed to be updated, and that the trial court itself erred by not holding the hearing. Well, they never requested hearings, so either, one, this court has already told the appellant that it's your duty to present evidence, which would mean if you believe that the court doesn't have current evidence or the full evidence, that you have a duty to bring it to the court, which then raises the issue of invited error. They didn't ask for the relief, they didn't raise the issue to the court that they thought that the issue was stale, that the evidence was stale.
What I'm saying is, under normal circumstances, when each husband and wife would file a motion for shared parenting,
Correct.
okay, they wouldn't have to ask for a hearing.
Right.
Because the court would hold one.
Right.
And so I think that's the argument they're making, that because the trial court committed error originally by not having the two shared parenting plans, that therefore the trial court had to hold a hearing, because they were filing, this was the first time the shared parenting plans were filed.
I understand what you're saying, Your Honor, but I don't agree with that that's the argument that they're making.
Okay.
The argument that they're making is that we had a trial, there was a bunch of evidence presented, going to the best interest factors. They appealed, it was sustained on one issue, which was that the trial court committed an error by essentially rewriting the shared parenting plan, rather than saying, hey, here are the issues that I have with the shared parenting plan, correct it and resubmit it to me, which is essentially what we did, both of us did. I think the reason that the trial court adopted my client's amended proposed shared parenting plans is because it complied with what it directed it to be corrected to in order for it to adopt it.
So you're saying it was not like a new shared parenting plan, just
No.
submitted?
No, it was just the parties complying with the court said would bring it into compliance with what it would adopt. And while all of us in this room can agree or disagree as to whether or not that's a form of a function issue, it's a legislative issue, it's not for us to decide, it was really just a procedural issue that was remanded on. This court remanded it to follow the specific procedural format that the legislature has laid out for submitting changes that the court has requested to a shared parenting plan that it would otherwise adopt. That's what we did, and it adopted it. So there was no need for a new hearing, simply by complying with the procedural nature of the submission of a shared parenting plan subject to its own.
And that's where I see what the appellant's arguing, in my view, and he can come up and correct me in rebuttal, is that in essence, at some point, the court has the discretion to make these findings about best interests as far as shared parenting. But there's an outer limit of that discretion. As time gets older and older and older, you're abusing your discretion by making a decision on information 4 years old. You're talking about what will go on the child's life at 4 years, and now the child's 8 or 9, and clearly that decision, there has to be new evidence taken to make sure how things are going, to make sure is this stuff relevant or not. And that's their argument, whether or not that's correct or not, but I take that to be their argument.
Oh, and I agree with you 100%, Judge Stevenson, sorry. That is their argument. The problem is whose duty is it to ask for the hearing.
Well, fundamentally, I guess they're saying it's the court's duty at some point to some point throw their hands up and say, look, I can't make this decision anymore fairly to this child and the child's best interest, so I have to have new information. That's what their position is. And I don't think there's any case law that says that, to be fair to them. I think they're upfront about that. They're not telling us anything different about that.
Right.
But that's what I think we're going.
I agree with you 100%. That's exactly their position. The problem is that this court told them on remand in 2020 that if you want additional evidence or any sort of evidence, it's your duty as a party to bring it to the court's attention. So if they wanted a new hearing, if they believed that the information was stale at any point, whether in 2021 or at any point between 2021 and 2023 when the decision came out, which, as a matter of context, the whole reason for the delay between 2020 and 2023 is the fact that there were repeated appeals. Mr. Godfrey got up here and said this is the third time we've been here. They've also tried to take discretionary appeals to the Supreme Court that have been denied. There's only been one appeal, one issue that they've appealed that's been sustained, and it's the one that's underlying this. So the delay and the staleness of evidence is driven solely by the fact that Judge Glass's hands have been tied because this issue has been on constant appeal since 2019. That's the only reason that she can't do anything, and that's the reason that there's no hearing and that these decisions are coming out when they're coming out is because it's constantly on appeal. This case has been pending for 8.5 years. 8.5 years. It was filed in February of 2016, and we're still here. So the fact that there isn't evidence that they believe is fresh or unstale falls solely to them. It was their duty to bring it to the court's attention, saying that we believe that you need to apprise yourself of changed facts, circumstances. Whether the court would have come to a different conclusion or not is pure speculation one way or the other. But it was their duty, and this court told them it was their duty to do it, and they didn't do it. So they invited the error that they're complaining about. It's not the trial court's duty. It's not the trial court's duty to try anybody's case.
If anything, do you think the trial court has an obligation or duty to act in the best interest of the child?
Absolutely, the trial court always has a duty to act in the best interest of the child.
If the trial court determined it was in the best interest to have a hearing in this case to get new information, would that have been permissible?
Sure, if it decided and said that I want to have a hearing, it absolutely could have.
And in your view, would not have in any way been contrary to our remand in this case to have a new hearing if the court wanted to?
Under the circumstances of this case and the timing of it, it would not have been an abuse of discretion for the trial court to do that. She chose not to. And I also believe that the trial court's decision not to do it is also not an abuse of discretion, given what Judge Carr mentioned as it relates to the remand, which was fix this very narrow technical procedural hiccup that happened in rewriting this parenting plan and just have the parties do what you wanted to do yourself. So she could have done either and complied with the remand, but she chose simply to follow the direct remand of this court, which is fix the procedural error and submit new plans, and then I'll make a ruling. The fact that she chose not to is also not unreasonable, unconscionable, arbitrary, or in any way contrary to this court's remand, no. I would just end, I suppose, with I can add on to what I just said, which is the trial court is presumed by case law that Ohio Supreme Court case law, it's presumed that there was regularity in the proceedings below. So that the fact that the trial court chose to follow this court's remand to the T, is presumed to be regular. That was cited in my client when he was representing himself on a pro se basis. In the Butler case, it really cites back to Miller, which is a 1988 case from the Ohio Supreme Court. So unless there are any questions from the bench, I believe that's all I have at this point.
Seeing none, thank you.
All right, thank you.
Thank you. not hiccup that the judge did. The judge inserted her own schedule. All of us who are in this courtroom understand that this is not a situation where perhaps the judge had changed plaintiff to defendant, mother to father in perhaps the statutory notices about right to access to records. This was not a hiccup. This was a major change that the court inserted that this court said you can't do. So disagree with counsel that it's a hiccup. Secondly, the court instructed the parties not to conform to, so to speak, her decision. You'll not find that in the record. What the court said was each party should submit their own shared parenting plan. That's what the record will show. So, although Chris says, the court said just fix your shared parenting plan to comply with my, being Judge Glass's decision, that's not what happened. What we were instructed to do was to provide, in essence, shared parenting plans. And to follow up on your question, Judge, how does a court make a decision on what is the children's best interest when you have two competing plans? That's the issue. The issue that Chris raises about delay, it's not accurate. We did appeal to the Ohio Supreme Court. It was denied. We never got in. That was it. So to talk about invited error and talk about delay, it is not resting on the appellant's shoulders. There was delay. I don't know why. It just happened. And that delay was not because of multiple appeals. There was one appeal to the Ohio Supreme Court, and that was it. The significance that I think we have to look at is what you said, Judge, and that is, if we all agree that the court has to look at the best interests of the child, what is that evidence? And to say that the court can just simply rely on something 5 years old, 4 years old, I think is abuse of discretion. And I also believe that it is incumbent upon the trial court, when it has competing shared parenting plans, to take new evidence. This is not a situation where it's 6 months and things don't change. Chris said, this case has been pending for 8.5 years. From the time of the remand, or from the time of the trial, to the decision by the court adopting father's plan was 4.5 to 5 years. People change, children change, circumstances change.
Counsel, I know your time is up.
Thank you very much.
The court will take the matter under advisement and issue a decision in due course. The clerk will mail a copy of that decision to its release. It will also be available on the High Supreme Court website. With that, I'd like to thank you both for your presentation.